Recording in progress.
Good afternoon.
Afternoon, Chair.
I guess it's almost time for us to start that we officially declare this meeting open and extend a word of welcome to all the honorable members of the other committee on the General Intelligence Laws Amendment Bill, but also express our greetings to our support team that is a force behind the work and the working of this ARO committee, our public at large, and also our media contingent. I believe that it's important that we also extend a word of greetings to our stakeholders that will be engaging today. And having said that, I think let's get a sense from the committee secretary as to whether do we have the necessary members to start. Committee secretary.
Good afternoon, Honorable Chairperson. Thanks to you for the opportunity. I'd like to also greet the honorable members, our stakeholders, as well as our colleagues. Chair, we do have a substantive number of members. We also, however, have 3 apologies, one from Honorable Dutoy, the other one is from Honorable BB, who are also engaged in other committee meetings. But the last one is from Honorable Nabuskachni, who will also join the meeting a bit later. So, Chairperson, I think the meeting can then carry on with the consideration of the said apologies. Thank you.
Thanks, Committee Secretary. Having said that, can you flight the agenda for today? Thank you. Honorable members, that is the agenda for today. It means the lineup for the oral presentations is as indicated. I believe that we must note the agenda as tabled, and then probably just give an opening remarks in terms of today's purpose. It is important that we appreciate the fact that today is mainly to give our stakeholders, as indicated, an opportunity to make their representation on the general law as indicated, which obviously is the General Intelligence Law Amendment Bill, which for the purpose of our stakeholders, just to remind them that the bill seeks to implement some of the key recommendations that were made during the high-level review panel that was appointed in 2018 by the President of the Republic, President Ramaphosa, and also to ensure that we incorporate the key recommendations from the Zondo Commission but also the key recommendations that were made from the panel that was appointed by the president to investigate the July 2021 unrest. And at the crux of this bill is to create two distinct intelligence services, both the domestic and also the foreign intelligence. But more than that, also to ensure that there is clarity in terms of mandate of this intelligence services and the intelligence agency, and also the academy. And it becomes important that we also put across the fact that this bill seeks to strengthen accountability and the regulations of these intelligence services. At the same time, to ensure that as this agency and the service will be doing their work, they do so within the ambit of the legislative and constitutional mandate. It becomes important also to indicate that the functions of the intelligence service, I think one get a sense because we move from the assumptions that no one underestimate the importance of intelligence services, particularly in terms of the work that they are doing, their functions. But the bill seeks to also ensure that there's no trust deficit between the citizens and the government, but also to ensure that there is no overreach. But the importance of public participation cannot be underestimated during this process. Hence, we need to appreciate the role that they have played. We know that they participated in the National Assembly processes, and as a result of those participation during the NA processes, a number of changes were effected following from the concerns that were raised by our stakeholders, particularly around the broad and ambitious definitions, and also the concerns that was raised around the broad definitions that would allow even the faith-based organization to be vetted, but also one of the concerns that were raised during the public participation in the National Assembly led to the changes being effected to allowing intelligence services to apprehend. But there are a number of areas definitely that would also want the stakeholders to have a bite on, and I'm putting them forward because they were raised during some of the public hearings that we have had thus far. Amongst them is the establishment of the evaluation committee in terms of the Secret Services Act 56 of 1978. This evaluation committee, a recommendation was made during the evaluation, during the public hearing, to be included. So the work of this evaluation committee seeks to ensure that there is oversight and checks and balance intelligence operations, particularly operations that falls under the Secret Services competency, but also how do you balance that, the 1978 Act, to ensure that it is in compliance with accountability and transparency. The second point also is the issue of that we want to hear our stakeholders also commenting on will be the issue of the deputy chairperson of the Joint Steering Committee of Intelligence. The law as it is now, we only have the chairperson, meaning that during the time when the chairperson is able to continue his function, the committee will then come to a halt because in terms of how he's appointed, it does not make provision for the deputy to be elected. So one of the proposals that were made during the public hearing is the need to have the deputy chairperson, which calls into question also the need to amend the bill. The third point that was raised also relates to the proposal that we legislate the biannual meetings between the Joint Steering Committee on Intelligence and also the President. These meetings are quite crucial due to matters of national security that require discussion exclusively with the President. The fourth point relates, which is administrative, is the alignment of the Joint Steering Committee of Intelligence annual reporting with the parliamentary reporting requirements. Is the fourth point that was made. But of course, like as you said, this is purely an administrative issue for proper alignment. And the fifth point relates to the appointment of the Deputy Director, the Deputy Inspector General of Intelligence. This is not just a procedural step, but also a necessity to ensure that the office functions efficiently and effectively, because in the instances where the Inspector General of Intelligence is unavailable, the work halts without a designated substitute, which potentially impede critical oversight functions. And having a Deputy Inspector General of Intelligence would ensure continuity and efficiency. So therefore, this is one of the proposals that was also made in one of our public hearings. So we'd want to hear the stakeholders, their views on this, with a view to ensure that this office is strengthened. Other than that, let me then just indicate that we believe that the presenters were given time allocations in terms of making their presentations, and after each presentations, we will allow members. Though I would propose that let's have all the presentations, and then as stakeholders make presentations, let's note our comments, our questions, clarity scheme questions only, because this is not a question and answer session. It's public hearing, it's oral representation. But what is quite important is that where there is a need to give clarity to proposals that are made, let's allow members to do that. What is also important also is to know that I think I'll get guidance from the team, because I don't see a Declares Foundation here. I think the committee secretary, I think from the report at the agenda, we don't have the FW Declared Foundation, meaning that probably their concerns have been addressed. Having said that, let me then, without any waste of time, give platform to COSATU, which will be led by Comrade Matthew Parks to lead the presentation. Comrade Parks.
Thanks, Chair. Yeah, thanks, Chair, and thanks all our members for giving us space. I'll just quickly put up our presentation quickly. Chair, I think the interest and the vantage point that COSATU has on the General Intelligence Laws Amendment Bill is that one we've seen, like all of us, in the previous decade or past decade rather, the abuse of intelligence services, and if that happens, it also gives space for the abuse of state power, for corruption, etc. So I think that's our vantage point. And of course, we've also seen at times where some politicians might want to abuse the state security services to interfere with civil society, even trade unions. So we are keen to see government kind of returning to the path of good governance and so forth. And I think for us, this is one of the critical bills. Chair, when we had seen the initial draft of the bill before this came to Parliament last year, we were quite alarmed by it. We were very, very concerned about the content, the clauses, the kind of general direction. But I think for this revised bill that was passed by the National Assembly that is currently before the NCOP, we do welcome it. We think there's been significant improvements in the National Assembly. And there also were some improvements before this also tabled in Parliament last year too by the State Security Agency as well, after some outcry from ourselves and from civil society. So I think we're quite pleased that a significant chunk of the issues have been addressed. That's positive. We had really expected significant battles. But I think the first draft of the bill for us was just unacceptable. We thought it was unworkable and many parts were just simply unconstitutional. Chair, but I think we had engagements, and I think Chair, you made an important point about the importance of public participation. So we had participated in the National Assembly hearings. It was not, I think, easiest of hearings, but I think we were quite pleasantly heartened by the amendments the National Assembly made to it. And I think for us that's quite positive. So we're able to now support the bill overall as revised by the National Assembly. But I think we do have a few additional proposals and conditions on our part where we think we could help strengthen the bill further. I think that's the kind of the issue that you're raising now, Chair, in terms of feedback from public hearings in the provinces, etc. Specifically around the findings of the Inspector General for Intelligence, that we think they should be made binding upon state security organs. But I think a few other issues too, which we can come to. Chair, for us, a lot of parts of the bill are administrative, so we didn't really stress too much about it. Initially, we were very concerned about the definitions of threats to national security. We thought the initial draft of the bill, released by the department, the definition was just simply excessively broad about what could be a threat to national security. It literally included everything under the sun, and that will make it unworkable, and it could also make it open to abuse. So we're quite pleased that with the revised definitions of threats to national security, as adopted in this current bill, we think they now presented quite a fair and a coherent and a constitutional clarification of what constitutes a threat to national security. And so we're able to support these. And we don't, I think for us it's about finding the right balance. You would always need to have intelligence and security organs. We do have general security threats. I think my colleagues might have seen articles in today's News 24 about issues of money laundering, going to terrorist organizations overseas, etc. They wanted to exploit our circumstances here. So I think the new definitions of threats to national security, I think for us they're fine. We support them. There's one very small typo which we picked up in clause 2B, subclause 9, a very small, silly little one. But just insert after premise and before Chief Justice the words and or. There might be some other further typos, and perhaps the parliamentary legal advisor will just want to go through it with a fine-tooth comb. It might seem, very silly at face value level, but I think all of our experience has been that if you don't fix the typos in laws, it can come back to cause problems later. But yeah, so I think I've covered this. But we do support the revised wording to the threats to national security. Chair, I made a small typo on this one. I should have changed the heading. We had also been quite concerned about the issues of monitoring of bulk electronic communications. The initial draft before the National Assembly, we felt was just too much of a blank check, to put it on that regard. And again, we've seen in the recent past how state security agents have abused that for very dubious purposes. So, Chair, we do welcome the revised wording on the bulk communications, as well as the checks and balances and the judicial approval for it. So I think for us, we get comfort for it, especially with regards to the wording that These will be governed by prescripts and, of course, overseen and approved by a judicial authority. We do have one proposal on it, though, Chair, that not in the bill perhaps, but in regulations, because the clause now speaks to prescripts to govern the monitoring of all communications and its approval. That's fine. We think, though, Chair, that those prescripts, because they're not ordinary regulations, they're very important. There's still a lot of space for mischief for these powers, which are significant to be abused. So our recommendation, Chair, perhaps we could go into the committee report, would be that the executive, within 12 months of the bill being enacted, should return with these regulations, release them for public comment, as is the practice and the norm, but also submit them to Parliament too for further consultation. I think that's critical, Chair, because often departments can just ignore public comments. And I think because these are not ordinary regulations, they have a real potential to be abused. So I think it would be useful for those regulations which govern bulk communication monitoring and intercepting should be brought back to Parliament, to the Joint Standing Committee, just for further consultation and to make sure they do, in fact, satisfy the objectives of the clause. Then, Chair, in terms of the vetting issues, again, the initial draft of the bill that was released by State Security last year, it was extremely worrying. We were very concerned as COSATU about proposals to extend vetting of persons who are not employed by the state, who are outside of the remit of the state, including bizarrely to civil society, to religious institutions. So we're very pleased that State Security did respond positively to that and remove that clause. And I think even the provisions have been further kind of tightened by the National Assembly, and I think we're comfortable with them now. And we're not saying, Chair, that NGOs or churches or even trade unions shouldn't be subject to some sort of registration, codes of conduct, monitoring, and etc. All of us should be subject to these, but these should be done by a relevant line function department. So NGOs should be scrutinized by the Department of Social Development. Trade unions are already scrutinized by the Department of Labour. In fact, there's a Register of Labour who's specifically employed to do that and to hold us accountable, which is correct. And I'm sure there'll be at some stage a need to do so for religious institutions, perhaps under the commission which deals with them. But we don't think those would fall under the remit of the state security organs. But we do think if you link this to the definitions of threats to national security, it does give the state security the right balance on the scope that if they think there is somebody who's creating, false NGOs to launder money for terrorist organizations, etc., they would still be empowered to monitor and to scrutinize those institutions. And so I think for us, Chair, the new wording provides the right balance to it. Chair, a significant part of our concern with the revised bill that was processed by the National Assembly and strengthened by them was really around the powers of the Office for the Inspector General for Intelligence. We have been quite concerned that, and one listened to the Inspector General himself, flagging numerous issues, that he struggled to appoint staff, to determine his budget, the state security would interfere, would undermine, would block issues, etc. And then also he raised concerns about his findings not being made binding and so forth. So I think for us, those are big red flags. He's got a constitutional role to play, and if he's struggling to fulfill that mandate, we should be deeply concerned. So we are pleased, Chair, that I think the ad hoc committee in the National Assembly side did a lot of good work. A lot of the issues around the OIG we think have been addressed. So, for example, the issue of appointing of staff, of managing a budget, etc. So I think for us, those are quite welcome. But I think, Chair, we are still concerned around the issue of the findings of the Inspector General being made binding upon the organs of state whom the Constitution mandated to monitor. So the current Inspector General has raised that many of his findings have been simply ignored by state security organs. So that has to be dealt with. Otherwise, what is the point of having the OIG? That really opens the door for abuse. So I think, Chair, for us, it was simply to elevate, to insert a simple clause to say that the findings of the OIG are binding upon state security organs. It can't be otherwise. It can't be a voluntary thing. It shouldn't be made of a proposal that if the intelligence feels like it, they can do it. If they don't feel like it, they can ignore it. So our proposal basically is just to insert an additional clause in that regard. And that's our second proposal, Chair, is that again to mandate the executive to return to Parliament within 18 months after the law has been enacted to see if there's a need for further legislative amendments to further strengthen and assert the authority of the Inspector General. But I think at least for us now, Chair, would be to have a clause which does make its findings binding. And I think we've had similar discussion with other other critical constitutional institutions like the Public Protector. Chair, in conclusion, I think we're pleased with the overall thrust of quite a substantially revised bill, as amended by the National Assembly as tabled before the NCOP. I think the majority of the concerns with regards to the previous drafts of the bill, especially with regards to threats to national security, have largely been addressed. The issues of vetting, we think, have also been addressed. We think there is a need for further work in regulations, and that those should release public comment and should come back to Parliament for consultation with regards to bulk communication monitoring and intercepting. And then also, Chair, the issue that we just mentioned a minute ago about strengthening the role of the OIG. We welcome the additional clauses around budgets, around staffing, etc. But I think we should take it to the logical conclusion now and also make the findings binding as well. Then, Chair, just lastly, with regards to the point that you had raised, into the issues flagged by public hearings, I think that for us, the issues of do you have an evaluation committee to monitor to valid intelligence? I think for us that makes sense, straightforward. You should find the right synergy and synchronization with the work of NECOC, which we think should do it. But there's a need for an enhanced process, which includes the JSCI, for example. That I think would make sense. A JSCI deputy chairperson chair, and similarly a deputy inspector general would largely be administrative issues, but Chair, we can see the logic of having that spelled out, because if it has credit issues currently, then why not take the opportunity to provide for that? And again, Chair, having biannual meetings with Parliament, we think it makes sense. It's a fair point. And I think Chair would really want to welcome, and I don't know if we have time now, perhaps we may not have time now because of the election cycle. Perhaps you can go into committee report in a further supplementary bill. But we would agree with the principle that we need to strengthen the reporting requirements to Parliament and also for Parliament itself. And I'm sure one can find the right balance between what is classified information, which shouldn't be disclosed publicly, but information which we think could be shared publicly, and the broad holistic issues, that should be done as well. So I think we'd welcome those kind of proposals from the public hearings. And whether we can get them done now, which might be very, very difficult, if not, then the committee report can recommend that further work be done after the action on a supplementary bill. So I think, Chair, let me stop there. That is our presentation. I'm sure we've saved some time for the committee's schedule, and I think just thanks for giving us space. We hope we've also helped with your important work. Thanks, Chairperson.
Thanks, for Comrade Parks for the presentation on behalf of COSATU. We have noted the views that you've expressed. Like as you indicated, after this, you get a sense from members what are the key areas that they might need clarity on. Having said that, let me then invite Intel Watch, Ms. Heidi Swart, to also take the platform. Over to you, Ms.
Hi.
Swart.
Good afternoon, Chair. Let me just quickly share my presentation. There we go. Okay, so I hope everyone can hear me.
Yes, we can hear you.
Fantastic.
You have the,
okay. Thank
the hosting rights.
Great. Thank you. So my name is Heidi.
We're still looking forward to your presentation. We can't see it.
Oh, you cannot see it.
Yes.
Hang on.
Can the team help?
Yes, I think that will be the quickest, if they can. Let me try one more time.
Committee Secretary? Okay, there it is.
All right, hang on.
It disappeared again.
Can you see my desktop?
Yeah, we see the desktop. Go
And now,
to the presentation now.
can you see the presentation now?
There it is, indeed.
Okay.
You can proceed now.
Okay, thank you. Sorry about that. Let's try again. So I'm Heidi Swart, and I'm the research coordinator for Intel Watch. We're a new organization, and we work in the field of research, policy, and advocacy to strengthen intelligence oversight. We've been in this field for a while because we did work as the Media Policy and Democracy Project for about 10 years. And so we are now a formalization of that collaboration between two universities, UJ and UNISA. So I'll get right onto it. Right. So we are worried that as the bill stands now, it's still not meeting its aim. It does split the agencies, the state security agencies, into its components, but on the whole, we don't think that it will prevent state capture. We don't think it does enough to react to the findings of the 2018 presidential review panel, the Zondo Commission's inquiry, the 2008 Matthews Commission, the 2006 report of the task team that reviewed intelligence-related laws, and the 2021.
We would appreciate just to see your face before you proceed, because this is live.
Hang on. Okay, just a minute.
There you are. At least now
Okay.
the public can relate with the voice behind.
Okay, good. Okay, I mean, and you can still see me?
Yes,
Okay.
yes, you can see.
All right.
Yes.
So yeah, well, in a nutshell, we don't think it's going to, as it stands now, necessarily prevent a second state capture. We are still worried about the definitions in the bill. So, for example, there's still no definition of national security. And what we found over the past 10 years, and not only in terms of the state capture era, but that because there's no solid definition of national security, we're in a situation where it's up to the services to decide. And that is, what falls within their ambit. And we feel that's too broad and it leaves too much room for interpretation. So with that, what makes it additionally broad then is this national security, intelligence, and even intelligence gathering. Again, stays too broad because we haven't got a solid definition of national security. We are particularly worried about the use of the term opportunity in the definitions. We're worried because it's a shift away from the intelligence services focus on public safety. And it's a shift away from international obligations. And then we find it's reminiscent of, for example, what you would have seen the CIA and so forth do in the past. What we don't want are security services that are going out of the country looking for example, economic opportunities to further the country's interest. We think that really the services should focus on the safety of South Africa's people, and they shouldn't wander outside of that ambit. We're also still worried about the oversight mechanisms, including the Inspector General of Intelligence, the Joint Standing Committee on Intelligence, and the Auditor General, and external bodies' abilities to investigate malfeasance within the intelligence community. We know that the JSCI and the IGI have struggled. There's been an inability in general, to implement the recommendations from the IGI following investigations. And we really, support the idea that the JSCI should have the power to tell the Inspector General to make very specific investigations. But we would also like the findings of the IGI to be binding, legally binding. And then also we want the AG, the Auditor General, to have full access. We want the Act to make it explicit that the Auditor General must have full access to the finances of the organization. In other words, what that would ideally entail is repealing the Secret Services Account Act and the Security Services Special Account Act that allows for budgets to be spent in secret. We saw during the Zondo Commission a testimony that bags of money were literally carried out. And the agency and crime intelligence as well as the domestic and foreign branches, the State Security Agency, we've never seen an unqualified audit. So we really feel that that's something that this Act could have fixed. Now on to the, I'm just going to say a few more specific things about the JSCI and the evaluation committee that I know that was also brought up in the recent notice that you sent this afternoon. We support the concept that there should be an evaluation committee. But it would be better if the evaluation committee had a stronger parliamentary component. The way the law is now, and I'm talking about the Secret Accounts Act, the way it is now, it's basically written so that the president can appoint and remunerate persons of his or her choosing, and then of course there's room for one opposition member. So we feel that there's no guarantee that we'll have input from the different opposition parties and from the public if we don't have members from Parliament on that committee. So ideally, we would want it to be a subcommittee on the JSCI. And in that vein, we'd like to support the idea that the JSCI and the subcommittee meets with the president twice a year. And of course, both the JSCI and the eval committee need to be equipped with expertise and security clearance for these experts in the field, so that they can really make informed decisions. And the evaluation committee also has to do continual reviews. They need to be keeping the JSCI up to date as to what's happening in the services, their covert operations, their overall strategies, etc. So someone needs to have a bird's eye view of what's going on the whole time. And then from there on, we can have the IGI doing more in-depth investigations if the JSCI feel that's necessary. In terms of the JSCI approving the intelligence budget, we need them, and also through the this is where the evaluation committee is also important. We need them to not just be a rubber stamp when budget gets allocated to the intelligence agencies. They actually need to know what the money is going for, and if it's being used in line with what was budgeted for and in line with our security strategies. And then finally, just we also like to support the alignment of the JSCI's annual reporting with the parliamentary reporting requirements. I think that'll be a great help for all involved and also help the public. Then a word on the Inspector General of Intelligence. We've said this has been heard before this today. The recommendations must be made binding once the IGI has done an investigation. I understand that the State Security Agency objected to this because they were worried that classified information would have to be discussed in open court, roughly speaking. So there's been a Concord ruling and there's been a recent Supreme Court ruling affirming the finding that the Minister of State Security cannot simply say, I'm sorry, documents are classified, therefore the court cannot have access. Ultimately, it's up to the court to decide which documents it can see and cannot see. And we know that our courts have discretion. We know that they have in the past shown great care when it comes to issues of national security. And I think we need to trust them so that when issues of that the intelligence, that the Inspector General has investigated, when that does come to court, that there is a way to take this to court. There can be in-camera hearings, and of course, the court can decide whether documents are unnecessarily classified, because that's also been an issue with the intelligence services in the past. If you don't want an inquiry, classify a document. And that's not a situation that we want to see continuing. Then, of course, there were also talks that the IGI's recommendations should require the concurrence of the services. While there's nothing wrong with talking to the services while coming up with recommendations, we really don't feel that the services should have some sort of final say over the recommendations. We feel this undermines the IGI's independence. Then, of course, there's the matter of establishing an office for the Deputy Deputy Inspector General of Intelligence. That was also in this morning's circular. We fully support the call for that. Otherwise, we're going to have a situation, as we've had in the past, where there has been a lack of continuity, where the IGI's office is empty, etc. Then, finally, we really need some references in the Act to whistleblower protections, or at least an anonymous hotline, so that we know for sure that when members in the service public turn to the IGI, that they will be allowed protections by the state. Then, briefly on the bulk interception, we are still worried that that is not adequate to protect us from what bulk interception could potentially be. So during bulk interception, there are various stages. There's the collection of communications, the storage, the analysis. We can't have those be left to regulations that the minister must still make, and that the minister can potentially make in secret and can change in secret. And those regulations can also be left in secret. We feel that that must be in this final act. The idea that those processes are secrets and cannot be in an act, that's not legitimate, because it's already common knowledge in the world how bulk interception works and how the stages work. And we really have to look at international precedent and start to make work of constructing legislation that is public knowledge, that really puts safeguards on how this powerful technology is used. The bill also really needs to make it explicit the role of the Chief Justice in appointing a judge that will be considering applications for bulk interception. That we need to be absolutely sure that this appointment cannot solely be the prerogative of the president. Of course, then we also need a definition of bulk interception. And that obviously goes with these regulations that need to be made, that it cannot not be in the Act, it must be there. I'm just going to quickly, while I still have time, move on to bulk interception and what it actually is. I just wanted to mention to get the idea across, that there is the idea that bulk interception is limited, that it's only scanning the airwaves and picking up certain signals. Bulk interception, I think, and legally, should be defined in its most extreme form, because that is what we're actually looking at. And as you can see from this slide, if you look at the bottom half of the slide that says new approach, this is a almost 10-year-old presentation from a technology company, Vastec, that's located in South Africa. And already then they had the technology to capture, as you see, all citizens' communications, analyze that communications, in other words, search for a specific person, and then find people to actually target. Okay, that is extremely dangerous, because what it means, as you can see here, they have intermediate storage, so they can store this. By the way, here it says intermediate storage, but they could store this information in the long term, as you can see here, or indefinitely, and search back in time. So that is what bulk interception is in its worst form. And I think the law really needs to take that into consideration. Right. Then security competence test, just quickly. This is to prevent what happened with Dr. Dentwe when he was our Inspector General, where he had his security clearance summarily revoked by the head of the SSA. What we think we need is a separate vetting department that's on equal terms with all the other departments of intelligence, that's well-staffed, that can actually take the time to make up our vetting backlog, because that's a real issue now, is that we have a vetting backlog, and it's utterly important that the Act addresses this. There needs to be a proper appeals process if for some reason your security clearance is revoked, and it needs to go through the vetting department. No one person should be able to summarily revoke anybody else's security clearance. And of course, we need more detailed vetting criteria. It's not enough for the bill to just say you're a national security threat or you can't be trusted. We need to have more information about how that happens. Security competence tests, we're very worried also that the SABC can still be considered critical national infrastructure, which means as the security competence, it's now security competence evaluation, but as it stands now, it is possible that journalists, editors, media professionals, and even visitors to the premises of the SABC can be vetted. So we would really like this bill to make explicit that security competence tests must not be misused to interfere with the journalistic integrity of the SABC. Additional crucial aspects, some of these I've mentioned, but I just want to say them again. The Apartheid Acts enabling the slush funds need to be repealed, and there needs to be proper financial management safeguards in place. The bill also still allows for ministerial overreach, what we saw during state capture, especially where the minister can get involved in operational details and the functioning of the agency. That needs to be corrected. There's not enough countering the illegal surveillance and targeting of non-profits. The targeting of the legitimate activities can still occur. We need to have those activities defined, and we need to have stricter rules as to when such organizations, if at all, can be targeted for surveillance. The idea that the agency members must neutralize or impede such persons, that needs to be removed from the bill. It's really, that is a dangerous phrase. If you look at the definition of neutralize, that any arrests, etc., restraint needs to be applied by the police. And finally, keeping the services within the presidency is dangerous. It needs to be reviewed, and there should be a time limit on it. We saw what happened during state capture. There's no guarantee that the future presidents will not go down the same route. And last, finally, there needs to be some sort of penalty for members who fail to cooperate with investigations into malfeasance in the organization, whether it's the JSEI, the AG, the evaluation committee, whether they're being investigated by the Hawks, the evaluation, the Financial Intelligence Center. Any type of interference, be it through overclassifications or be it through, for example, weaponization of vetting, that needs to be addressed. For example, you don't want a situation where they can say, look, we're going to withdraw NPA members' security clearance because they're getting too close to the truth. So all that stuff needs to be addressed, and there needs to be penalties for this. And of course, surveillance, and not just surveillance, but operations targeting civil society. There needs to be explicit penalties for that. It's just not acceptable that the services have gotten away with, as we saw during the Zondo Commission, with actually, surveilling civil society, and for no good reason. And that concludes my presentation. Thank you very much.
Thank you. Thank you, Ms. Haid, for the presentation. Quite explicit in terms of the views and proposals that we're making. We definitely Yeah, appreciate that. Having said that, we will then invite the next presenter, which will be Ms. Les Pretorius from the Freedom of Religion, South Africa.
Good afternoon, Honourable Chairperson. I'm Liesl Pretorius, the Freedom of Religion, South Africa. I will just quickly share my screen and then just start my presentation from the beginning. May I proceed, Chair?
Thank you. The platform is yours.
Thank you. Thank you so much. So, Freedom of Religion South Africa is a non-partisan, faith-neutral legal advocacy organization mandated to uphold the constitutional right to freedom of religion and related rights. The bill that was just called that the NA Bill for short contained vague, overbroad, and even circular provisions. Religious institutions and leaders potentially could have been seen as a national security interest and even a threat to national security and subjected to mandatory security competency tests. And the consequence of failing to obtain a security clearance certificate was also unclear. So the draft versions of the bill and the National Assembly bill raised various serious freedom of religions concerns, even including state regulation of religion and the oppression and suppression of the religious sector, because the bill was so broadly worded that if it fell into the wrong hands, a person with a bad agenda could abuse it. Now, our approach and point of departure also in the National Assembly is that protecting the Republic's national security is vitally important, and upholding the Republic's constitution and democracy, protecting fundamental rights and freedoms, including religious freedom, is equally important. And we have always been committed to making constructive proposals, and we are very grateful to say that the bill that is before this committee is a marked improvement, and we recognize the hard work done by the ad hoc committee in the National Assembly. We think this most of our most significant concerns have been addressed. So our mandate is quite narrow. It's freedom of religion. And from that perspective, this presentation will just briefly highlight the differences between the NA Bill and the B Bill that is before the committee, what we consider also to be significant improvements, and any remaining concerns. Now, we noted that the B Bill does not include and therefore does not substitute existing or introduce new definitions. And these ones are domestic intelligence, foreign intelligence, national security, and persons or institutions of national security interests. So the first three are existing definitions in the Act. And the last one would have been a new definition. But the B Bill will no longer introduce different definitions for these. The B Bill also proposes updated definitions in comparison to the National Assembly Bill for intelligence gathering, for opportunity. In the National Assembly Bill, it was opportunity or potential opportunity, so it's been just shortened to opportunity. Also for security competence assessment, the National Assembly Bill referred to security competence test, and also a different definition for threat to national security. The B Bill includes the same definition as the National Assembly Bill for national security intelligence, and it does not define what a threat is, and neither did the National Assembly Bill. Just moving through the provisions, Clause 4A of the B Bill, which is similar to Clause 3A of the National Assembly Bill, which concerns mandatory vetting investigations by the national intelligence structures. In this version of the bill, it no longer includes a reference to personal institution of national security interest in terms of Section 42AI of the Act. And in Clause 3B of the bill before this committee, provisions are introduced concerning the consideration by judges of international law, the provision of reasons for decisions, the management of bulk interception of data, and the surveillance arising from bulk interception. So what do we consider to be improvements? We consider the removal of the reference to opportunity or potential opportunity from the definitions of domestic intelligence, foreign intelligence, and national security to be a significant improvement, because this concept, opportunity or potential opportunity, in the previous version of the bill, it is a very vague concept, it's an overbroad concept. And in the previous version of the bill, when definitions were read together, it actually introduced circularity into the bill. We also note, and we are grateful for the removal of the reference to potential opportunity from the definition of intelligence gathering for the same reason. Then we think this is a massive improvement, is the removal of the reference to person or institution of national security interest from the definition of security competence assessment. The inclusion of that part made the definition of security competence assessment vague. It made it overbroad, which leads to the bill, would have made it open to abuse. And it also could, read with other provisions of the Act, could have subjected religious institutions and the leaders to mandatory security vetting, which we would have seen as irrational and impractical. Now, turning to the other clauses of the bill, so we're moving away from the definitions, the reference to person or institution of national security interest has also been, it does not feature in clause 4A of this bill before the committee. It's equivalent to clause 3A of the bill before the National Assembly, but this reference to person or institution of national security interest is removed from the current version. This is a very big improvement, because we believe that this actually makes the bill more rational and practical. It's rational and practical to limit mandatory security vetting to persons and institutions who actually need security clearance to be employed or to render services to an organ of state, have access to classified information and intelligence, or who have access to critical infrastructure. So now it's a much narrower, tighter definition. We also see that the current version of the bill has no proposal to amend the definition of national security. And we believe that the existing definition, which was introduced by an Amendment Act of 2013, is more robust than the amendment which was proposed in the NA bill. So welcome that. And we definitely welcome the removal of the definition of persons or institutions of national security interest, because we believe that it's a vague and overbroad definition. We also see the introductions of new sections that relate to the consideration of international law, the providing of reasons for decisions taken by judges, the management of bulk interception and surveillance as an improvement, because this will better protect fundamental rights and freedoms and will comply with constitutional jurisprudence, including providing for post-surveillance notification. Then there are one or two remaining aspects that we believe are rooms for improvement. The definition of national security intelligence still refers to potential opportunity, which, as I've said before, is a vague and overbroad concept. What is a potential opportunity? That's very vague. And this reference to potential opportunity have been removed from other definitions. So we don't know if that was like a little something that slipped through. Then the definition of opportunity no longer refers to potential opportunity in its title, but it's still quite a vaguely worded definition. It includes capability, measure, activity. It doesn't really limit that. So that is something that can be looked at to perhaps create a bit more legal certainty and to ensure that there's no room, for a door to be open to abuse. But we will look at this more in detail in our written submissions that we will be submitting to the committee. And then the concept of threat remains undefined. In our submissions to the National Assembly, we requested this concept to be defined because our view is just that it's such a key concept. It's repeated, many times in the bill. So perhaps we'd just add a bit more legal certainty if this concept was defined. And then a significant difference between the current version of the bill and the one that was before the National Assembly is the definition of threat to national security. The current definition is much, much, much shorter. It is a threat to national security includes any act or mission which may potentially cause damage, harm, or loss to national security. Shorter definitions are not necessarily clearer definitions. This definition, and we will look at it more deeply in our written submissions, but any act or mission, that's quite broad. Damage, harm, loss. If these terms are not defined, they can be very broad terms. They can even be a bit vague. And we don't want legal uncertainty. We don't want the door open to abuse. So we believe that that is a definition that might need a bit more scrutiny. And that concludes our presentation. We'd like to thank the committee for the opportunity to address the committee on our concerns. And again, just commend the work that was done to improve this bill. Thank you.
Thank you, Ms. Lizel, for the opportunity that you took to take us through your presentation. Having said that, I will now invite Mr. Bhavesh Padiaki from Stellenbosch Law Faculty
Good afternoon, Chairperson.
also take the podium. Floor is yours.
Thank you.
Do you have the hosting rights to share your presentation?
Yes, I do.
Thank you.
Chairperson, I can't share my screen.
Committee Secretary, can you help Mr. Padiaki?
It's all sorted now, Chair. Thank you.
Thank you.
Thank you.
Should I do it? Okay, there you are.
Okay, thank you. Thank you, Honorable Chairperson and members of the National Council of Provinces, for permitting me the opportunity to address you today. As a point of departure, I think it's important to acknowledge that this bill represents a pivotal moment in South African history for intelligence purposes, particularly concerning the governance and oversight of intelligence agencies within South Africa. The submission aims to provide a comprehensive analysis of the bill, highlighting its background, key issues, and potential implications for democracy. With that being said, I aim to cover the context, origins, key concerns, potential impacts, proposed actions, acknowledgements, sources, and further reading, and final remarks. Before I continue, I think it's important to acknowledge that this submission marks the second iteration of the bill, following extensive criticism from academics, civil societies, and public, which was heard in the National Assembly. The revisions made by the Assembly have been fundamental. It's provided a much richer second document. However, there are still some vague definitions that I will unpack in the slides for consideration of this House. The first of the definitions would be the consideration of national security. National security, as defined by the bill, includes any action or omission which may potentially cause damage, harm, or loss. While this is a revised version of what was initially presented to the National Assembly, the definition needs to be restricted or refined in a better sense. Because while a different section of the bill aims to make reference to define the bills or constrain the definitions within section 198 of the Constitution, 198 does not specifically restrict the definition. Instead, it provides an idea of national security. So instead, I think the House should consider looking at section 1 or 2 of the Constitution. This provides a more fundamental view on the provisioning values of the Constitution. It allows for the definitions to be tested in a much narrower sense, and it provides for a much clearer definition for the bill. Moving on to the discretionary powers, the bill confers a significant amount of discretionary powers upon the Director General and the Minister. I saw in the National Assembly the main reason for doing this was that the State Security Agency had a lot of red tape in fulfilling their duties. So by mitigating the red tape and allowing the Minister to have direct access to make decisions by himself, It enables the new intelligence services to perform their duties faster. However, in so doing, it allows for abuse of power. It allows for avenues in which the minister or government may abuse certain powers. It may mislead the trust of the public. Discretionary powers, there are certain ways in which government can, perhaps the bill can propose that the minister is held more accountable to Parliament to provide quarterly reports instead of annual reports, or perhaps that certain decisions need to be referred to Parliament after it's been made by the minister for review. Another consideration by one of the academics was that Prof. De Vos mentioned that one of the considerations could be to establish the intelligence agencies as a Section 9 institution or Chapter 9 institution of the Constitution. This would allow that they function independently. They would be able to have independence from government so that they are not pressured into doing it. Similarly, this is how countries like the US and the UK do it with the FBI and MI6. These are independent institutions which are reportable to the minister but don't fall under the minister. Privacy concerns with regards to the bill's definition of intelligence gathering. There's a lot of ambiguity in the scope. I think the bill aims to, the definition for intelligence gathering is a very wide array that should be refined in terms of Section 1 or 2 of the Constitution. Perhaps the National Council can provide a clearer definition, a more specific definition of intelligence gathering. I provided this graphic from Dear South Africa, in which a survey was done with more than 20,000 South Africans. These figures were presented to the National Assembly as well. I think it's important to note that while there were revisions made in the National Assembly, in the bill, the current form of the bill that's before the National Council, two of the primary concerns is still vetting, the right to privacy, and mass surveillance. I think it's important for members of this House to take that into consideration when we talk about revising the bill. Most South Africans are not in support of the bill in its current form. They all feel that more revision should be done in protecting their rights. With regards to foreign bulk interception, as my colleagues have said previously, this is a concern. It's not clearly defined. To take note that Section 2B1, as proposed by the bill, makes reference to the RICA Act, and the Constitutional Court deemed certain sections of RICA unconstitutional. So I think the House must be wary of which sections are being referred to. More importantly, I would like to focus on the appointment of a retired judge to head up this foreign bulk interception department. In line with the Constitution and the doctrine of separation of powers, it might not be in the best interest for the role of the judiciary to have to perform within intelligence. This was similarly seen in Heath versus the President of the Republic. The only difference was that the judge in that position was an active judge. In this form, it is a retired judge, but the judge still takes up other positions afterwards. By being accountable to the president, it puts judges in an awkward position. More importantly, the reason behind why the judge should be appointed was that judges are knowledgeable on the matter and on the law. However, we need to consider that judges aren't the only people in South Africa who are aware of the law. There are advocates, attorneys, professors who can take up this position instead. In that way, we protect the strict separation of powers that South Africa has, and we don't compromise the work of judges or the judiciary. As I said before, certain sections of the bill make reference to RICA. It's important that the House takes note of which sections are being referred to and that it's not the parts that are included in the unconstitutionality. Implications, if the bill continues in its current stance, it risks undermining the principles of accountability, transparency, and the rule of law. The bill needs to be reworked. It needs stricter definitions. While it's come a long way, there's still a heightened risk of executive overreach and posing a direct threat to the democratic fabric of South Africa. Recommendations are that the definitions are first clarified, they are more specific, and that they are founded on provisions within the Constitution. By linking these to more specific definitions within the Constitution, it makes the definitions more testable. We can test it against other rights in the Constitution, and it restricts the definition in that sense. The limitation of discretionary powers, the best way to limit the minister's powers is to make him more accountable to Parliament without imposing red tape or restrictions that prevent the department from doing its work. The notion of safeguarding privacy rights, it is, I think, once there's a clear definition of foreign bulk interception and what a national threat is defined in relation to rights within the Constitution, safeguarding of privacy rights will be clarified. Enhancing judicial oversight, the appointment of someone other than a member of the judiciary would help with that. Alignment with constitutional principles. There needs to be more foundational values that are mentioned in this bill instead of the wide and broad definitions that are used. In conclusion, the General Intelligence Laws Amendment Bill represents a crucial juncture to South African legislature. The concerns outlined in the submission are adopting the recommended amendments. Parliament has the responsibility to commit itself to enhancing the democratic governance of South Africa. By amending the bill and fixing the definitions within this bill, it strengthens the transparency and accountability within the intelligence sector. Failure to address these issues risks eroding public trust in government and undermining the foundations of democracy in South Africa. I'd like to acknowledge the ad hoc committee and members for hearing and for the work that you've done on this commission so far, as well as the academics and organizations who've made work in drafting this bill, as well as moving it forward. As a final thought, Prof. De Vos left a very nice quote that I think is important for this House to acknowledge. He's noted that in a constitutional democracy, unlike in a national security state, national security should not have anything to do with lawful political activity, advocacy, protest, or dissent, regardless of whether such activities challenge or seek to undermine supposed shared values or national interests. The bill in its current form poses a threat to the political activity or democracy in South Africa. I think it's important for the House to take this into note when drafting and revising the bill. Thank you, Chair.
Thank you. Thank you, Mr. Pariachi, for taking us through the thrust of your presentation. Having said that, we will then take this opportunity then to invite Professor Jane Duncan to also make a presentation to the other committee. Over to you, Prof.
Thank you very much, Chairperson. I don't think that I have screen sharing rights, if I'm not mistaken.
Can the team help, Prof, to have screen sharing rights?
Kindly bear with me. I'm having serious network challenges because I keep getting kicked out of the meeting. And I think that's why some of the co-hosting rights have been taken away. But Prof. Duncan is now sorted. Thank you.
Thank you, Committee Secretary. Prof, you're sorted out.
Thank you very much. All right, thank you very much for the opportunity to address you today. And one of the advantages of being the very last person to present is that it seems like there's very little else to say, because I think a lot of the points that I wanted to make have already been made. But I did want to start out just by making a very general point about this particular bill and the context in which it's happening. Because while I think overall the bill is welcome, and particularly the main objective of the bill, which is to separate or disestablish the State Security Agency and to separate out the foreign and domestic branches and establish them with their separate directors general. So in other words, to break down what has been described as the architecture of abuse that enabled widespread abuses of the intelligence services, including the State Security Agency under the former president, is finally being addressed. But it's not being addressed in the best of contexts. In fact, ideally, what should have happened was that we should have followed a process whereby we start out with a national security strategy, because we're now making structural decisions about how to reestablish civilian intelligence in the absence of a revised national security strategy. And ideally, structure should follow strategy. And there's been more than enough time to actually revise and finalize a new national security strategy and release it to the public for consultation, so that we have a national consensus on what the principal national security threats to the country are. Following the national security strategy, it would have been appropriate to move into questions of the architectural structure of the intelligence agencies, including civilian intelligence, and then proceed to a general intelligence laws amendment bill. So to actually start out with the bill is unfortunately to put the cart before the horse. And one of the things that has been raised by a previous presenter, which I just want to amplify, is the fact that there hasn't been any substantial public discussion, certainly not in the context of these hearings, around the appropriateness of the State Security Agency resting with the presidency. Now, what I'd like to argue here is that while the Constitution provides the president with the prerogative to decide whether to have a separate Minister of Intelligence or whether the president delegates somebody else to play the ministerial role, which at the moment is the minister in the presidency, who is a very busy person and has many, many other things to do. One can make the argument that to an extent, this new arrangement has weakened executive oversight because we don't have a dedicated Minister of Intelligence. All of these things, all of these issues need to be reviewed. And while one can acknowledge the fact that the prerogative around these decisions rest with the president, it could be appropriate for this committee to add a note into the report to the National Council of Provinces expressing concern about the fact that the bill is being considered in the absence of a national security strategy and an architectural review that does a thorough analysis of all these issues and then provides a sound basis on which to legislate. And that a recommendation could be made by this committee through the National Council of Provinces to the Joint Standing Committee on Intelligence to make sure that those two processes actually do happen, if belatedly. All right. Now, just to move on to the questions of the definitions. While I would agree with a number of the other presenters that some of the most problematic aspects of the definitions in the previous version of the bill have been addressed, and notably the removal of most references to potential threats and potential opportunities. There are certain definitions that still remain too broad. So, for instance, intelligence gathering is one of those, in that it still refers to domestic or foreign opportunity or threat to the advancement and protection of national security, which is a very broad definition. And also national security intelligence as well contains a reference to advancing any opportunity or threat to the national security of the Republic in any field. Opportunity is defined, but it's defined very broadly, and it refers back to the definition of national security in Section 198 of the Constitution, which in itself is broad. In a nutshell refers to freedom from fear and freedom from want, which is the human security definition of national security, which could lead to a situation where the National Intelligence Service and the agency pursue intelligence collection and analysis on a broad range of issues that could actually stray into the mandates of other government departments. And there has been a point made, for instance, that we've seen foreign intelligence agencies, particularly in Western countries, abusing overbroad definitions that incorporate exploiting opportunities, including economic opportunities, to spy on politicians, to spy on trade negotiators, to spy on companies in an attempt to try and steal a march for their respective countries on foreign trade-related issues. And we don't necessarily want to do what these kinds of agencies are doing. We want to do intelligence differently, and we want to do it better. So I think that there's a strong argument to be made to not just simply go with the herd on these issues, but to actually exercise thought leadership on how to narrow intelligence practice in a way that rolls back these kinds of global abuses that we've seen of intelligence capabilities. So my suggestion would be that the underlined words in the respective definitions, and in fact the entire definition of opportunity, is removed. And then in relation to the oversight of foreign and domestic intelligence, I think the point has already been made that it remains problematic that the Inspector General of Intelligence does not have the powers to make their recommendations binding. It, to an extent, cuts across any efforts to make the Inspector General's office more independent than it already is. And the fact that there have been strides to give the office more autonomy, I think is very, very welcome. But those amendments that have been made by the previous ad hoc committee, I think, fall short in that they haven't taken the attempts to increase autonomy and ultimately independence to their logical conclusion, which is to provide the Inspector General with the powers to make those recommendations binding. And my understanding of the reasons why this decision has been taken is because that there's a fear that the National Intelligence Service or the agency may take the Inspector General's findings to court, which may result in classified information being revealed in court. But as a previous presenter has argued, if we actually look at the case law on national security matters, we should actually have confidence in the fact that matters that have gone to court and have been ventilated in court have actually strengthened national security and have had a positive impact on the culture of accountability, executive accountability of the intelligence services, and also while dealing with national security matters in a sensitive matter, the courts have also dealt with national security in a robust matter as well, and failed to simply accept the overclassification of intelligence documents. So I don't think we should fear cases being or matters being taken to court if there is a disagreement with the Inspector General's findings. And one of the ways of actually lessening the potential for that to happen is for the National Intelligence Service and the agency to just simply comply with the decisions that or the recommendations that have been taken by the Inspector General, because unfortunately we've seen that not to be the case, and as a result of that we have a long list of legacy issues that still need to be attended to by the service and the agency. And my fear is that the procedure that has been put in place by the ad hoc committee, which involves an attempt at a deadlock breaking mechanism, firstly at the level of the minister and then secondly at the level of the JSCI, may not be sufficient. It may lead to second guessing and in fact unacceptable delays, to the point where the pile of issues that need to be dealt with by the Inspector General just continue to pile up. I also have a concern that in the discussions around this issue in the ad hoc committee, there appears to be very little distinction that's been drawn between the two main functions of the Inspector General's office, which is the assurance function or the certification function, and the ombud function or the complaints receiving and adjudication function. Now, while there may be a stronger argument to make that final decision-making around the recommendations of the Inspector General in relation to the assurance and certification functions should rest with the JSCI. I've made an argument that that shouldn't be the case, but I recognize the fact that there is still an argument to make there. While there may be a stronger argument to be made in relation to that set of functions, I think there's no argument to be made in relation to the ombud or the complaints adjudication function. Because what is the JSCI going to do if it wants to review decisions that have been taken about complaints that have been brought to the Inspector General? Is it going to go ahead and hear all the evidence all over again that has been presented to the Inspector General? It's just simply not practical to expect that to happen. And in fact, we've seen in the Dutch situation, for instance, where this distinction has been drawn and where in relation to the assurance function, the Inspector General there has the powers of recommendation only, but in relation to the ombud function and specifically in relation to third-party complaints, recommendations or decisions that are taken by the Inspector General in respect of those complaints are binding. And then I'd very much like to associate myself strongly with the suggestion that came through the ad hoc committee and now has been brought back to this committee for the need for a Deputy Inspector General. Many of the abuses that were documented by the high-level review panel on the SSA and subsequently by the Zondo Commission related to a period in time when there was no Inspector General. And during that 2-year period, all manner of abuses could be pursued within the SSA because there was no proper oversight taking place. And we don't want that to happen again. And one of the ways to ensure that it doesn't happen again is to ensure that there is a deputy who can work arm in arm with the Inspector General so that there is continuity on an ongoing basis. In relation to the security competence test, I think it's welcomed that this test has been narrowed to people who access classified information and critical national infrastructure, which I think is as it should be. It's appropriate. It was never appropriate for these tests to apply to persons of national security interest, because in any event, the service and the agency have more than enough capabilities to be able to investigate such people if they are of concern. However, it's possible that critical national infrastructure, because it's quite broadly defined, could also encompass the public broadcaster, the SABC. And I think it's important that there's a caveat that's inserted which excludes SABC journalists from security competence tests on media freedom grounds, because we don't want those tests to be used in an attempt to try and compromise those journalists' confidential sources of information. Then in relation to bulk interception, the section certainly has been improved, but I think that there are still matters that could be improved further. And we only need to go back to the Constitutional Court judgment on RICA and on the National Communications Centre in order to get some kind of guidance on what needs to be improved. So the Constitutional Court had said that it would be looking for a legal framework that spells out in its words the nuts and bolts of the centre's functions. And it also needs to spell out in clear, precise terms the manner, circumstances, or duration of the collection, gathering, evaluation, and analysis of domestic and foreign intelligence. There, I think it made a slight error because bulk interception should apply to foreign intelligence collection only, not to domestic intelligence. But yes, those were the that is what the Constitutional Court said it would be looking for. And we want to avoid a situation where this bill is taken back to the Constitutional Court on the grounds that it falls short of these particular requirements. And my feeling is that it does fall short at the moment because there's too much detail that's been kept for the regulations, and that detail should actually be included in the primary law. And the main reason for that is that regulations are really controlled by the minister. And we want the ground rules for bulk interception, given how incredibly invasive this capability is. We want the ground rules to be set through Parliament and through a public process, and not through a ministerial process, because as we've seen in the past, ministerial regulations can take an incredibly long time. There are many regulations that still haven't been developed that are essential, crucial to the functioning of civilian intelligence that still remain outstanding. So there's a backlog of regulations. But also many of these regulations, in fact, most of these regulations tend to get developed and adopted in secret. And we don't want that in relation to some key issues around bulk interception. And these are the issues, in my view, that need to find their way into the primary legislation. So the grounds on which a bulk interception may be authorized, the circumstances in which an individual's communication may be intercepted, I've set them all out there. These are internationally recognized benchmarks that have been developed in the past couple of years, particularly in the wake of the abuses that were of bulk interception that were disclosed by former NSA contractor Edward Snowden in response and in an attempt to try and tighten up the spaces for abuse. These international benchmarks have been developed, so they're quite recent, they're quite topical, they're current, and I think that they are highly relevant to South Africa's lawmaking too. And then an oddity, which I did raise in the previous hearings, but I see it remains unaddressed. The National Communications Centre falls under the South African Intelligence Agency, which is the domestic agency, and not the South African Intelligence Service, which is the foreign agency. And this, to my mind, increases the potential for abuse. Now, this may have happened because the center has two main functions, which is a cybersecurity function and a bulk interception function. But we know from the past, and this has been canvassed exhaustively in previous Inspector General reports and the Matthews Commission, that the National Communications Center has been abused in order to spy on politicians and on business people and on journalists domestically. So there's a history of abuse of these capabilities that should be used for foreign bulk interception being used domestically. And because of that, I think we should err in favor of rather placing it in the foreign branch rather than the domestic branch. And in any event, the high-level review panel recommended that it sit in the foreign branch precisely because of this history. And then in relation to the detention and arrest of agency members. So I think that there was an attempt to respond to the public perception that the bill would authorize agency members to arrest other agency members. And this has been responded to by stating that one of the functions of the agency will be to impede and neutralize members that are suspected of contravening the Act. Now, I feel a bit conflicted by this because we've had such an incredible recent history of abuse of state security agency capabilities that obviously we want these people to be removed from the agency's employ and premises as quickly as possible. But we don't want to do so in an unprocedural and unlawful way. And my feeling is that this particular amended clause may still not cut the chase when it comes to recognizing that people who are accused or agency members that are accused of abuses too have rights. And in fact, this clause could be used in order to detain agency members unlawfully, and it could even amount to kidnapping. So my suggestion is that this clause is removed in its entirety, and we rather refer, we have a clause that refers cases involving members suspected of unlawful activities to the relevant law enforcement agencies for further investigation and, if necessary, for apprehension. And then there is still a lot of work that needs to be done around the apartheid era Secret Services account and the Security Services Special account. I strongly agree with the recommendation that's now come back to this hearing, that the evaluation committee that was meant to be established in terms of the Secret Services account be established. It is quite shocking, in fact, that it hasn't been established. But that is not all that needs to be done. The evaluation committee will continue to operate on fairly broad grounds, because in terms of the Secret Services Act, it merely needs to show that the covert activities that will be funded by the Secret Services account are in the national interest, and national interest isn't defined. There are other issues relating to the uses and abuses of secret funds that need to be attended to. So, for instance, in relation to the State Security Agency, there's been a bias towards covert operations, which is highly unfortunate in an era increasingly where we have more and more opportunities for open source intelligence collection and analysis and more overt forms of intelligence collection. There appears to have been a bias towards covert operations. And one can certainly make the argument that the ease with which intelligence agents have been able to access the cash advances through the cash advance system that these two particular acts enables has led to a bias towards covert operations funded through cash. And in addition to that, there has also been a major problem where the State Security Agency has been able to roll over its surpluses subject to very light touch authorization by Treasury, and then use those surpluses the following year. And this has led to a situation where other structures within the State Security Agency have been starved of resources in order to create a larger surplus that can then be rolled over and withdrawn through the cash advance system and plowed into dubious covert operations. All of these problems are authorized, if you can put it like that, by these extremely problematic and lax apartheid era acts that need to be reviewed. So while we can say in the short term, it's important for the evaluation committee to be established, because then at least there's some form of oversight over decisions around the funding of covert projects. In the longer term, I think there's a very stronger argument for the entire architecture of covert operations and how they're funded, and the circumstances under which they're authorized to be reviewed, and that would necessitate a review of these particular acts. Then lastly, I think that there is still some work to be done around ministers becoming involved in operational matters. There is a clause from the Intelligence Services Act that has just simply been repeated in the bill that is highly problematic, because it says that the minister may, subject to this act, do or cause to do all things which are necessary for the efficient superintendence, control, and functioning of the agency or intelligence services center or academy. And this has led to a disagreement that was aired quite extensively at the Zondo Commission between a former minister and the evidence leader, where the former minister was saying, but actually the act allowed me, authorized me to become involved in operational matters. So I think unless and until this particular clause is revised, then I think we're going to have this lack of clarity, and it's going to open the door to ministers to continue to become involved in operational matters. So my suggestion is that this particular clause is revised to ensure that the minister is confined to executive oversight only. I know there was a slight debate in the previous ad hoc committee around the definition of superintendence, what it covers, because it could potentially be understood to cover aspects of control. But I think rather replacing the term superintendence with the term oversight, I think should cover that particular problem. And then I also saw the circular this morning in connection with the additional issues that the committee wants to seek input on. And I think it's very, very welcome and very important that these issues are coming back. But I do have a question, which I'll get to at the end of my presentation, about these particular issues. I've spoken to the evaluation committee. I've spoken to the Deputy Inspector General. The Deputy Chair of the Joint Standing Committee on Intelligence, I think, is a very good idea. It's very important to, I think, have two hands on deck when it comes to the leadership of the JSCI, rather than having one hand on deck. One of the problems, the legacy problems that we've had with the JSCI is that with each new parliamentary session, we have a loss of institutional memory, and the JSCI almost needs to start from afresh. There's often very little continuity between old members and new members. I think having a deputy chair of the JSCI doubles the chances of at least one of those members who've served in a leadership capacity coming back into the new JSCI with all their institutional memory, and I think hopefully only enriching the discussions that take place there. The biannual meeting between the president and the JSCI, I think, is an excellent idea. we've seen many problems arise because of the lack of regular meetings between the president and the intelligence structures, including the JSCI. And I think this should hopefully prevent a situation that we've got at the moment, where we have a huge backlog of policy and legislative issues that need to be attended to, because there hasn't been a regular meeting schedule. And then aligning the reports, the reporting cycles of the JSCI with the reporting cycles of Parliament, I think is also very important, because we've had situations in the past where there can be a lag of anything between 18 months to 2 years between when the JSCI completes a report and when they come into the public domain through the parliamentary process. There's also been a backing up of a range of recommendations that have been made by the JSCI that haven't really been attended to. So I think an alignment of the reporting cycles should help a lot of the problem issues that the JSCI has identified in their oversight of the intelligence services to come into the public domain and to come to our attention much more speedily. And then the question that I think I've got for the committee is, in bringing these new issues back, what does it mean for the work of the committee? Is there a possibility that the bill will be held over for the next parliamentary session? Because obviously there are risks if that happens. So I think if we can just get some clarity on the procedural implications of reintroducing these new matters.
Thank you, Prof. Is the Prof done?
Yes, I am.
Thank you, Prof, for the presentation. I think the last question that you posed just to unfold. Changes effected by the House of the NCOP. A referral will have to be made to the ad hoc committee of the National Assembly. If they agree with the recommendations from this ad hoc committee, there will be no problem. But where they have a different view, then that's when we will then have to relook at these issues. But definitely if because we want this new architecture to be the legacy of this sixth administration, and we cannot afford any delay. And therefore, I suspect we'll have to cross the bridge when we get there. We might also have to be conscious of the fact that where there is a different view, usually the matter can be referred to the mediation, but we don't want this bill to go through that process. These issues are quite important. I guess it's a matter that will have to be resolved at a particular time. If there is a need, there are recommendations that are made by some of the stakeholders that the recommendation could be taken. to ensure that the seventh administration are able to make follow-ups on some of the issues that are emerging from this public consultation and public hearing. So therefore, it's a matter that is on the table. We want these issues to be not to delay the passing of the bill, but they are quite important because they emerge out of the lived experience of the last 5 years of the work of the Intelligence Committee in Parliament. I guess this addresses your issue, Prof.
Yes, it does. Thank you very much.
Thank you. Honorable members, there is a last, but I think it's a matter that I need to raise with Mr. Kanzi, because Mr. Kanzi has also raised some issues, but the comments that Mr. Mutasi Kosi has made has nothing to do with the bill. It raises concerns that we definitely take heed of, and we therefore make a commitment that the comments made by Mr. Mutasi will be referred to the relevant parliamentary committees. We appreciate the concerns that Mr. Mutasi has raised. So therefore, as part and parcel of ensuring that we hold the executive accountable, that the raises will be referred to the other parliamentary committees. What we will then do, honorable members, we will then open the floor for clarity-seeking questions in relation to all the presentations that were made, clarity-seeking questions from presentations that were made by our stakeholders. And then what we'll then do, we'll advise members when as they rise to indicate which presentations are they relating to, so that at least there's no confusion, so that there is clarity in terms of who the clarity question is directed to. Thank you, honorable members. I see Honorable Shaik has raised her hand.
Thank you very much. Yes, thank you very much, Chairperson. Let me also take this opportunity to thank the various organizations and individuals that have made input on oral input into this piece of legislation. Chair, I'll just home in on two of the presentations. The first one is from COSATU, and thank Mr. Matthews Parks for that presentation. In essence, Chair, I think COSATU indicates that they support the bill overall, but they've also made a few proposals. I'd want to maybe seek clarification, especially in terms of their submission with regards to the findings of the Inspector General of Intelligence on the intelligence organs. It is constitutionally mandated to monitor that these findings should be made binding. If I can get your comment, or Mr. Parks, would you, COSATU, agree that enabling the Joint Standing Committee on Intelligence to entrust the IGI to conduct oversight through investigations would contribute towards the attainment of practical, if I can get that comment and or agreement from Mr. Parks or from COSATU. Chair, the other presentation that I would maybe want more clarity seeking questions is from Ms. Swart, the Intel Watch presentation. Chair, I think the Intelwatch is of the view that the absence of a definition for the meaning of national security is highly problematic. But given the changing intelligence, safety, and security environment, both nationally and internationally, would circumscribing what national security means not limit the ability of the intelligence services to operate in instances of emerging threats not yet contemplated? If she could comment on that. And the second issue, Chair, Intelwatch is also of the view that the bill does not provide sufficiently for the independence and powers of the IGI, JSCI, and the AG. Perhaps does the proposed further matters related to the strengthening the role of the JSCI, which the chair listed earlier, that do you not think that these address this concern to some extent? So I think those are just the two questions that I have for clarity that I have for Intelliwatch. I think, Chair, that those are the questions for clarity for myself. Thank you very much.
Thank you, Honorable Shaik. I see there are no other heads. Let me pose a question to Mr. Padiachi. Because in his view, Mr. Padiachi indicate that significant discretionary powers is conferred upon the Director General and the Minister, and that this raises accountability and checks and balances concerns. It might be important just for Mr. Padiachi to indicate which powers, in his view, should the Minister not be able to confer upon the Director General if such conferral is to be limited by the bill. The second one relates to the view that he expressed in relation to his interpretation on the national security with regard to Section 181 of the Constitution, which does not restrict the definition in any way. Given the changing intelligence, safety, and security environment, both nationally and internationally, would circumscribing what national security means not limit the ability of the intelligence services to operate in instances of emerging threats and not that are not yet contemplated, and also there are the results of a survey that Mr. Padiachi screened to as part of his presentation, and the stats that are contained in slide 7 and 8 in his presentation, I've got a sense that there was no distinction from his side that those views that were raised related to the bill as it was introduced to the National Assembly and not public views as on the bill as amended through the NA process, which I think is quite an important distinguishing factor, because it can create a confusion that the stats around public views that are in slide 7 and 8 relates to the current bill that we received from the National Assembly process. It would be nice just to get his views on that. And then the other questions as I move forward relates to Professor Duncan, which clearly emanates from the view that she advances around the disestablishment of the SSA and how the new architecture will be. Prof raised says the contentious issues emanate from the bulk interception as raised by the public was addressed during the National Assembly consideration of the bill. A legal provision and accompanying safeguards outlined in the Constitutional Court judgment. Prof was able to raise that, and that the bill has introduced a robust two-step authorization process for bulk interception, which requires authorization within the intelligence service itself and independent judicial review. I think that distinction is quite important, as this will ensure that the interception is conducted within the boundaries of the law based on genuine security concerns. Prof is of the view that too much detail in the respect of the management of bulk interception, bulk data is being kept for the regulation and should be in the primary law. So the question on this one, Prof, would be, what provision should, at the minimum, in terms of Prof's view, be provided for in the bill? I think that will be quite helpful. But I think more than that, you also raises the view that the bill is silent on reforms that are needed for governance of the Secret Services account. That the proposals that is made is that is the establishment of this evaluation committee within 12 months after the act is passed, not addressing these concerns to a certain degree. Just to get clarity from Prof in terms of that. Other than that, it will be important to get a sense from Prof, particularly her views in relation to the absence to the national security strategy. It will be important just to get a sense from Prof, which are critical aspect that Prof is of the view that should be covered in the national security strategy that should be considered, I believe, by the department. Other than that, let's give over to the stakeholders to respond in terms of question raised according to how to the line in which they were posed. Let's start with the Comrade Parks.
No, thanks, Chair. Chair, I think there's just Honourable Sheikh who just giving questions to us. I think largely on two parts. But yeah, Chair, so look, I mean, overall, we do support the bill as COSATU because of significant improvements we've seen in the National Assembly and a little bit before that as well. I think if those changes hadn't been made, we would have not been able to support the bill. So I think we really kind of welcome those kind of improvements, not perfect, but significant improvements, but enough to give us, comfort to address our deep concerns initially. Chair, just so I think basically two kind of areas for Honorable Sheikh. In terms of the bulk communications, so I think, look, we appreciate in a bill you have the kind of foundation clause, and then out of that bill will come out of the regulations. So we are comfortable that with regards to bulk communications, it speaks to prescriptions, which we would assume would mean regulations, and of course to a former judge giving approval for it. We're comfortable with the former judge, Chair, because, well, one is that they're a former judge, they're retired, so they're not dependent upon the state for their career, etc. But I think, Chair, we would answer the rationale of a judge, and a judge is normally the kind of person they go to in that instance, as opposed to yourself or myself, because one is that they have deep knowledge of the law, but also they have got deep practical experience and judicial institutional memory. So I think that's what we are assuming, also because they're respected, by the positions of authority, etc. And I think we've seen in South Africa, judges have not been afraid to hold the state accountable. So I think we're comfortable with that. But I think what for us is critical, because look, there's still a lot of space for mischief. Intelligence agencies across the world, in South Africa, have always had problems, including around bulk communication not so long ago, 5 years ago, 10 years ago, 12 years ago in our own history. So I think, Chair, it's just a simple thing. Can go into the committee report, would not necessarily go into a bill per se. Is that when the regulations are drafted, they should be drafted quite soon, because you don't want to kind of create a legal limbo that the state security moves, but there's no prescription or no regulation. So it should be done, we would assume, within the 6 months of the law being enacted. I think, secondly, Chair, for them to put out public comment, which is the norm for all regulations. But again, one doesn't want to assume anything or take anything for granted. But I think, Chair, because Parliament has played a useful role in amending this bill, it would be useful. And often regulations don't come to Parliament, but I think, Chair, it would be useful for these regulations to come to Parliament to allow further consultation. Yes, the executive drafts at the end of the day, but I think, Chair, given the history, given the sensitivities, it would be useful for the JSCI to have an input there. Chair, this to the Inspector General's office. When you listen to the OIG's or the Inspector General's submissions to Parliament for quite a while, they don't paint a good picture. How the office has been undermined, and I think we all have seen the previous instances where previous Inspector General was basically sabotaged by state security, etc. So I think there is welcome amendments in the current version of the bill with regards to the staffing issue. I mean, it is ridiculous to have the IG complain about not being even able to appoint a PA. So that kind of showed you the level of problems. So I think the provisions with regards to staffing to the budget, I think that's useful, Chair. But Chair, look, those are fine. Those are housekeeping issues. They're important. But if you don't make the findings of the Inspector General binding on the state security agencies, then as the Inspector General said, not us as COSATU saying, the Inspector General is saying to Parliament, a significant number of his findings was just simply ignored. And Chair, I think we've gone through this legal debate as a country with the public protector, or the previous public protector, and I think our very progressive principles established in law, the findings should be binding. If not, then what's the point? Then it's just a press statement and doesn't have teeth. So I think for us, the one thing we could get out of it would be to simply make the findings binding, and that'll be a very powerful thing. Chair, should the JSCI be able to request the Inspector General to undertake investigations? No, definitely yes. Members of Parliament speak on behalf of citizens. They have different viewpoints, they come from different political parties, they're noisy like the rest of us. And if they feel that there's a need to, and they don't have confidence in state security bodies to do it, then definitely would support that. There shouldn't even be, a debate. I think lastly, Chair, that we would assume members of Parliament would want to get done sooner. I'm a bit skeptical it would get done in time for the elections, given the submission and closing date, etc., and needing to get concurrence from the NA if you make any changes. But we think whether the bill is passed now, which is tight, or passed after elections, that it would be good after 18 months or so to do a supplementary bill to see if there are any other additional measures that could be looked at, which you could have had additional 18 months experience to see if there's any further work. But I think, Chair, I think I've answered Honourable Sheikh's questions. I think that was it from my side, Chair. Thanks very much.
Thank you, Colette Parks, for the response to the questions posed by Honorable Shaik. Let's go to Ms. Swart.
Okay, right. So I hope I understood these questions correctly. The first one is that essentially national security should not be too narrowly defined. I must I must apologize. I know it's a typo that says no definition of national security. It was supposed to be no clear definition of a national security threat. That said, defining national security clearly is it is not, national security is not an infinite, it's a finite concept, right? There are internationally agreed upon intelligence practices, fields of intelligence, different type of intelligence collections. There's covert operations, there's espionage, there is by now there's cyber intelligence. So there are different aspects to it, and there are different mechanisms to collect intelligence. Then there's also the way that the Americans look at covert operations, which they basically define as, for example, influencing other countries' elections, secretly funding non-profit organizations where people don't even know that they are actually working for the CIA, etc. So even within that broad ambit, where intelligence can be misused to manipulate political situation in other countries, there are limits to what it means and to what intelligence's ambit is. Let me just get the act here. The General Intelligence Laws Amendment Act of 2013 does actually define national security. And there are a couple of aspects to it. For example, hostile acts of foreign intervention directed at undermining the constitutional order, terrorism and terrorist-related activities, espionage, sabotage, etc., serious states of violence. If you take that definition, it already appears as if there's quite strong limitations on it, right? But even in this context, and I'll show you now how it can be misinterpreted, even with this so-called expanded definition, for example, terrorism. When is it terrorism? We need a legal definition in here, or we needed to refer to a legal definition of terrorism to make sure that when we accuse somebody of being a terrorist, we actually can put that in law. That isn't in here. Another very simple example is if you look at the definition of national security, they will say it does not include lawful political activity, advocacy, protest, or dissent. So political activity can very quickly be unlawful. If you don't have a permit to hold your process from the municipality, it's unlawful. So it's very easy, using the current definition of national security, to argue that putting a non-profit under surveillance is justified in terms of national security. I mean, Greenpeace was under surveillance. Greenpeace Africa was under surveillance because almost a decade ago they hung a banner on the walls of Coburg, and so that has put them on the sort of, on the list of potential terrorists. That needs to be evaluated. I mean, 10 years later, it was a banner. Yes, it was a critical infrastructure, but does that really warrant them being spied on today? So to answer your question in two ways, the definition of national security is already broad as it stands here, even with its various criteria and aspects here. But there's no definition of threat to national security, which is what we really need to be looking at. And you need a definition, with inclusions and exclusions, as long as your arm, to really make sure that it's not abused. And those limitations need to be written with the abuses in mind and the abuses that we have seen so far. I don't want to say it's impossible, but you're going to have a difficult time having a definition that excludes new risks. The risks have been established in terms of intelligence services, for decades, and that is a foreign onslaught on a country's sovereignty, and internal threats such as violence, etc. So, in terms of a safety perspective, it does need to be limited. Otherwise, you have the international practices that the ANC is so critical of, where there's external interference in another country's economics, there's external interference in other countries' politics. We don't want our intelligence services to be able to do that. And then quickly, in terms of the JSCI, the IGI, and the oversight, I think what the previous speaker, there's a lot you can say about this, but what the previous speaker has just said really just cuts to the matter. If the IGI doesn't have legally binding, can't make legally binding presentations, recommendations, then we're still stuck where we were during state capture and before that. None of the changes here made is going to give the JSCI or the IGI more teeth, because essentially the way it stands now, the law shields the the state intelligence services. This law shields them from scrutiny by the courts. So, and because the courts are essentially, not explicitly brought into the process of oversight, it will remain problematic, and that's why we're saying that the law isn't strong enough. I hope that answers the question.
Thank you, Ms. Schwartz, for the responses to Honorable Shaikh's questions. Let's then move to Mr. Padiaki.
Thank you, Honorable Chairperson. On the first question of the significant discretionary powers of the Minister, I think in terms of the bill, the particular sections I was concerned with is that the Minister is unilaterally entrusted with the approval of requests, the appointment of the head of respective agencies, the head of the academy, as well as the head of committees. This is all defined in Section 17E of the bill. Moreover, in terms of Section 34A of the bill, it defines that the Minister may cause to be done all things which are necessary for the efficient superintendent's control or function of the agency. This is a wide definition which entrusts a lot of power upon the Minister. So I think a secondary check or better appointment process would mitigate these processes or these concerns, as well as coming back to the fundamental issue of vague definitions. I think if Section 34A could be defined better. I know it was discussed in the National Assembly, the definition of efficient superintendents. I think if it could be clearly defined in the bill, it would resolve that issue. Moving on to the second question regarding the circumscribing of the definition of national security in terms of Section 198 of the Constitution. Particularly in terms of Section 198, with the growing and changing nature of cybersecurity or cyber intelligence in the world, there's definitely a growing definition of intelligence. It expands every day from what we learn from countries abroad. I think, however, by applying Section 1 of the Constitution to restrict the definition instead, Section 1 is based on the foundational values of freedom, human dignity, and equality, which is broad enough of a definition to accommodate for the growing nature of intelligence on a daily basis, without imposing on the rights and human dignity of or protecting the public. So by using Section 1 instead, it's a broad enough definition that the Minister and the intelligence agencies can work with, but it's restrictive in the sense that it doesn't allow for abuse of power on the public. And then finally, on the third question of the figures presented through the survey, I acknowledge that the statistics presented today were reflective of that on the bill in its first form. And while there have been revisions, unfortunately, there hasn't been a more recent survey conducted. However, I think a lot of the main concerns raised in the survey initially speak to those raised today by my colleagues, that of vetting, surveillance, and privacy. I think it's still important that the House bear in mind these statistics. It has relevance for bull, and while these figures have changed, a lot of fundamental issues are still present today. Thank you, Chair.
Thank you, Mr. Pariachi. Prof. Duncan.
Okay, thank you, Chair. I'm going to address your three questions, I think, by starting with the third question first, around the national security strategy and what it should contain. And just to start out with a point that it's actually apposite for us to be having the conversation about revising the national security strategy now, because revised national security strategies usually happen with new political leadership. If there's a new election, a new 5-year cycle, you have a revised national security strategy, which then sets out the vision for national security and the understanding of what the major national security threats are of that particular administration. So this is why I think it's important, you know, if this committee could consider including a note to the NCOP, you know, making that particular argument. It's apposite for it to happen now. So happily, a couple of years ago, I wrote an article on national security strategies, what they contain, what they don't contain, and what potentially ours could contain. So I'm just going to make reference to that particular article. So a national security strategy is usually a high-level document that sets out a country's strategic vision for national security and the major threats that it faces and how government intends to go about addressing those particular threats. So it also reflects on the longer-term strategies that are going to be used, as well as the resources that are needed in order to realize those particular strategies. So typically, a national security strategy would spell out the core national security values that the country agrees on, and this is why public participation is important in the finalization of the strategy. So it should set out the core national security values of a particular country. It should spell out the core objectives and assess the major national security interests and threats to the country. Otherwise, if we don't have a common conversation and understanding about these things, we can land up talking past one another around what the agency and the service should be doing, for instance. So a strategy will help us proceed from the same point when it comes to what they should be doing. It should spell out the priorities for responding to these threats and the security sector actors that should be involved or should lead on the implementation of the strategy. And typically the National Security Council is the custodian, and it leads the process of developing the national security strategy. And the National Security Council, I think, has been quite deafening in its silence, even recently, around key processes that are going on around the reform of intelligence. And I think that is problematic. So we have a National Security Council that has been re-established. There's a National Security Council Act. We don't really know what the National Security Council does. Here is something for the council to do, to lead the process of revising and developing a new National Security Act for the new dispensation. So the strategy should also outline oversight over the key actors that have been identified, how they will be overseen, and the resources and the partnerships that are needed to achieve their objectives. So, setting all of this out in one document can take us away from a situation where we have what's been referred to as an adhocracy, where approaches towards national security and the involvement of different actors isn't really guided by a single document that has been widely consulted and widely understood. So that is in response to your question around the national security strategy. In relation to the Secret Services Act, I think that the most fundamental thing that needs to be done in relation to the Act is to have a conversation, and I think this perhaps relates to the national security strategy as well, about under what circumstances should the agency and the service resort to the use of covert operations. As I said in my presentation, there's been an overuse or an excessive resorting to covert operations because there has been almost a financial incentive to push intelligence collection and analysis towards covert operations and covert action, because that is where the money lies. And we've seen, under the previous president, how covert operations, special operations have been used, drawing on the cash advance system in order to act as a form of Praetorian Guard or spear, if you like, to preserve the interests of the former president. So I don't think we've had a proper conversation about within what the service and the agency does, how much of it should be overt, how much of it should be based on open sources of information, how much of it should be covert, and in what circumstances should one resort to covert operations. Are there other ways of funding covert operations other than the cash advance system? Because it's that particular system that has turbocharged corruption in the soon-to-be former State Security Agency, because it's been so easy to make a case, often trumped up cases for covert operations in order to gain access to cash. And this has led to a range of ills that we know of. People writing off their personal bonds for their houses, safe houses, people, agents inventing sources in order to pocket the cash. All of these things have been part and parcel of the corrupt drivers or the drivers of corruption, because it's just been so easy to resort to covert operations funded by cash. So I think that's the main conversation that we need to have. And I think once we've had that conversation, then a lot of other wrongs will be righted in terms of how the intelligence services use and abuse their capabilities, because you would have removed the fundamental incentive for much, if not most, of what has gone wrong in civilian intelligence in the past 10 years, which is the financial incentive. It's the cash incentive. And then in relation to bulk interception and what procedures should be provided for in the primary law, it's the procedures that I touched on earlier. So I think that there's more detail that needs to be provided on, for instance, the grounds on which bulk interception may be authorized. There's just a general reference to bulk interception being undertaken in relation to national security threats. But the thing is, bulk interception is conducted for strategic intelligence purposes, which is of necessity more broad-ranging and longer term in its vision than other forms of intelligence collection, because you don't know what you don't know. You don't know what threats are looming on the horizon in the longer term to the country. So potentially bulk interception could cover everything and everyone, which is obviously not what we want. So I think that, and the agency will know this, they will know the circumstances under which they've resorted to bulk interception. So I think they need to spell out the grounds on which they feel bulk interception may be authorized, and we can engage with that. The circumstances under which one moves from bulk interception to more targeted interception, and what are the procedures for handling that particular transition from untargeted interception to targeted interception. What are the procedures for granting authorization? There are very detailed procedures that are set out in RICA, for instance, in relation to domestic interception. I think a similar level of detail could be included in the Act in relation to bulk interception. The procedures to be followed for selecting, examining, and using intercept material, the precautions to be taken when communicating material to other parties, including foreign intelligence partners. Are there circumstances, for instance, and there don't appear to be at the moment, are there circumstances in which bulk interception is shared with intelligence partners that have fewer privacy protections than we have at the moment? In some countries, intelligence services are forbidden from exchanging bulk intercept intelligence with such intelligence partners. But the bill is silent on a precaution like that. There's no detail on the limits on the duration of interception, the storage of intercept material, and the circumstances in which it should be erased or destroyed, how long it's stored for, and the procedures around the supervision by an independent authority of bulk interception and ex post facto review as well. So I think if some more detail around those issues could be included, then I think that would certainly help matters.
Thank you, Prof, for the response to the questions that we have posed. I want to believe that at this point in time, let me just ascertain as to whether there any follow-up question. Honorable Labuskarne.
Thank you very much, Chairperson. Yes, thank you very much. Thank you for the presentations and the input. I just want to get a little bit more clarity on someone referred to the fact if we don't amend the Act when it comes to the IGI, and the fact that he or her recommendation should be legally binding, and also included the Joint Standing Committee on Intelligence on that. I would like to know, are you talking specifically or a little bit more, should you say that should be the normal yearly reports, or what we call on the certificates that's been that all of the intelligence services has to report on, and the IG has an oversight on that? Or should you include all the investigations that the IG is supposed to do in that findings and recommendations? Thank you. I ask this question because I totally understand why are you asking that. That puts the IG in a position with a lot of power. You know, either it's the power, some of the power as is that you say the minister is all centralized in the minister. If you do that, a lot of power has been centralized in the IG. But then if you bring the Intelligence Committee into that as an oversight, there could be a balance. And I just want to need to understand if I understood it correctly, and what kind of decisions you think should be included and more be legalized in this process. Thank you.
Thank you, Kathy. I suspect it was you, Prof. Duncan. Prof.
Yes, sure. I did touch on the two main functions of the Inspector General, which is the certification function or the assurance function and the ombud function. And my view is, while there is a stronger argument for the IG to have recommendation powers in relation to the certification function, I think given all the practicalities involved in making the JSCI the final arbiter of all those issues that are raised on the annual certificates, I just think that it's impractical and in fact quite dangerous to not have the IG making recommendations that are binding. It will just speed things up. And also, we should bear in mind the fact that we have had an unfortunate history in the past of the JSCI not being particularly functional. We don't know what's going to happen in the future. So we certainly don't want a situation where we hobble the Inspector General's office once again with a situation where they are unable to actually act on the recommendations that they've made in the various certifications, such as we've had in the past. Now, yes, you'll end up giving the Inspector General a lot of power, but the Public Protector has a lot of power too. The Public Protector it has the ability to or has access to remedial powers in relation to the findings that they make. And we just need to make absolutely sure, as we've seen in the past, that we need to get that particular appointment right. I think having a Deputy Inspector General will dilute the powers somewhat, which will decrease the potential for that particular office to be captured in a way where that power is abused. But given the recent history that we've come from and the backlog of legacy issues from the certifications processes, I would prefer to see a much more streamlined, faster arrangement where the Inspector General can make those findings and can act on them, both in relation to the certification function and most definitely in relation to the ombud function.
Thank you, Prof. I think I need an advice. Okay, Ms. Swart, I see your hand is also up.
Yes, I just want to also add to what Prof said. Another thing I think to bear in mind is that the courts will also keep a check on the IGI. I mean, that person will have to prepare the case, and they'll have to be, they will have to take the process seriously. Otherwise, I think they're going to get into quite a bit of trouble, with the court itself. So for me, I'm not too worried about overreach there, because there's another check on the system. Thank you.
Thank you, Ms. Swart. I thought maybe I must bring on board our legal advisor here on the question that Prof posed in relation to the new issues and its impact on the ability to have the changes effected by the National Assembly, because it must definitely go back to the other committee. Those new issues, any input that you want to make there, Tati?
Good afternoon, Chairperson and honorable members. Chairperson, this bill is being processed in terms of Section 75 of the Constitution. And in terms of that section, Chair, if there are any changes, say for argument's sake, the changes that are now currently before the committee, which have been referred for public consultation, which are new issues that were not in the bill as referred from the National Assembly. Those issues, Chair, in terms of Section 75, subsection 2 of the Constitution, would have to be referred back. Section 75, subsection 1C, Chair, where the Council makes changes to the bill as referred to it by the NA, by the National Assembly, they would have to be referred back to the National Assembly for consideration. And the National Assembly, Chair, in terms of that section, has two options. One is to accept the changes, Chair, as submitted by the National Council, coming from this committee, or reject such clauses, Chair. Thank you. So those are the two options. If the committee does not make any changes to the bill as introduced, Chair, as referred to it, the bill would have to go to the president for assent. So those are the three options, Chair. One, if there are amendments, go back to the National Assembly for consideration of the proposed amendments. The second one, the committee in the Assembly can decide to take or not take the changes as proposed, and then subsequently the bill will then be referred to the president for assent. The other option, Chair, which is the third way, is if the committee does not make any changes, the bill would then be referred directly to the president after this committee. Thank you, Chair.
Thank you, Nat. I guess the Prof is quite clear in terms of the process as outlined, prompted by the new issues that are introduced in case they are adopted by the committee and accepted by the House. I'm advised that that I might have put the cart before the horse on COSI, because COSI also wanted to make a presentation, but I did make a reflection, but for the purpose of completeness and not at the risk of undermining the importance of public consultation. Maybe I must give Mr. Kosimutasi just an opportunity to have his views heard by this oral hearing. Kosi? Especially, I think you have had the benefit of the inputs from other stakeholders. What's your view? What's your take?
Greetings, Chairperson, and thank you for giving me a chance to voice my opinions. So, as you have let the committee know, my oral submission is not entirely based on the General Intelligence Laws Amendment Bill, but I'd like to say that lack of national security shows through the amount of important illegal goods, exported stolen goods, and undocumented foreign nationals. But this is not my focus today. The July 2021 unrest really showed how South Africans are struggling due to poverty. I could say 4 out of 5 people who caused destruction during the unrest were Black, poor, and desperate people. I'm not saying what the people did was just and correct, but I'm saying if government had provided jobs to these people at that point in time, I can assure you over 50% of the damage that was done wouldn't have been done. With that said, I would say the biggest problem in South Africa is poverty. And I say this because the people of South Africa really struggle, and I say this is what pushes the crime rates even higher. Most youth is unemployed, and the parliament and government are actually implementing rules that could have worked during like 10 years ago or something. My argument is times have changed and we cannot be implementing laws and rules for people who now have internet and things like TikTok and like social media as a whole. Because one thing we need to realize is that South Africa could be pushed to greater heights, but the stubborn problem here is the poverty part of our country. I'd like to suggest to Parliament that they try to put more younger people into Parliament so that the younger people can actually find stronger means of tackling the poverty and unemployment of youth. Because as much as I do believe honorable members of parliament and the government are doing a great job at tackling the problems of our country, having younger people within the government and within parliament would actually, what's this word? It would actually make a bigger difference, because now we have people who actually relate to the struggles.
Are you done, Mr. Tassi? Thank you for the inputs that you have made. Like as you have indicated, we indeed take heed of the concerns that we are raising within the context of the challenges emanating from crime, from poverty, the interconnectedness between that and the need to strengthen the responses in terms of policy imperatives. We will definitely, as we indicated, make sure that such issues are referred to the respective parliamentary portfolio committees. Will definitely do that. I think at this point in time, let's take this opportunity to indeed express a word of gratitude to our stakeholders for the appointment that we have had with them, and also affording our stakeholders the necessary platform to take part in this public participation process on the GLAP 2023. Your input will contribute to a well-balanced and thoroughly consulted law that seeks to improve South Africa's intelligence services. Just a reminder to our stakeholders that the committee will welcome written inputs, particularly in relation to the issues that are raised. You have until the 12th of May 2024 to do that, because the issues that emanated from the public hearings are quite important, and it is important that we also get the benefit of those written inputs, such that as we deliberate, as we create a necessary platform for various responses to be given, let's have the benefit of your written inputs. Having said that, let me also then take this opportunity, probably just for guidance in terms of the agenda. I believe that Committee Secretary will have sufficiently dealt with the issues that were subject matter of our agenda. Doc?
Yes, Chairperson, you are correct.
Thank you. Thank you. Let me then take this opportunity to indeed express a word of gratitude to our honorable members for making this meeting a success. More so given the congested programs of committees that we have. They were able to juggle around, but they saw the importance of ensuring that our process of this other committee is not delayed, is not impacted. Hence, a special word of gratitude to them. But more than that, our stakeholders, indeed, we want to take this opportunity on behalf of the other committee to also express our appreciation, like I did, for honoring this public consultative process. Furthermore, the special word of gratitude to our parliamentary staff that is behind the smooth running of this committee. Your contribution is also appreciated, and our public at large that are observing these proceedings, our public, our communities, also a word of gratitude to you and our media contingent. Let's continue to work together to ensure that finally this work is taken to its logical conclusion. So therefore, this meeting stands adjourned. Thank you.
Thank you, Chair.
Thank you.
Bye.
Bye.
Thank you, Chair.
Thank you, Chairperson. Thank you so much.
Thank you for your time.